Good morning, everybody, and welcome to the December 19th Board of County Commissioners meeting. Would you all please rise for the Pledge of Allegiance? I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, first thing on our agenda are our minutes from our last meeting. Gentlemen, do you have any additions or corrections?
I do not.
I move to approve the proceedings of Board of County Commissioners for December 12, 2023, as presented.
Second.
It's been moved and seconded to accept the proceedings of the Board of Commissioners, Montezuma County, for December 12th, 2023. Any further discussion? All those in favor?
Aye.
Aye. All right. Okay, next up is planning. Come on down. And this is a continuation from November 14th. Mr. Lewis? Kim, would you call the roll, please?
Commissioner Candelaria.
Here.
Commissioner Lindsay.
Here.
Commissioner Copenhaver.
Here.
Administrator Anderson.
Here.
Attorney McLaren.
Here.
And Kim Purcell, Montezuma County Clerk and Recorder. Notice is hereby given that the Montezuma County Board of County Commissioners will hold a public hearing for review and determination regarding a proposed 4-lot moderate subdivision and rezoning application submitted by Ellis Lewis on property located at 14171 Road 36.75, Mancos, Colorado, consisting of 39.66 acres more or less, located south and west of Highway 184, situated in Section 34, Township 37 North, Range 14 West, N.M.P.M. The hearing will be held Tuesday, December 19th, 2023 at 9 a.m. in the Commissioner's Hearing Room, Montezuma County Administrative Offices, 109 West Main, Cortez, Colorado. Interested persons may attend and give input. Information may be obtained from the Planning Office online services at https://co-montezuma-co.smartgovcommunity.com public home. You may also contact the Planning Department at 970-565-2801 with questions. Dated this 14th day of December 2023, Kim Purcell Clerk, Board of County Commissioners, Montezuma County, Colorado. First published in the Journal on Wednesday, November 1st, 2023, and this is a continued public hearing from November 14th of 2023.
All right, thank you, Kim. Okay, Don, I'll come back to you to give us just a little bit more of an overview. We've already had the overview, so.
And I guess just before we get started today, I think just given what happened at the first rendition of this public hearing, I think it's really important to understand that what we're here to do today is to address this 4-lot subdivision request and this application that's been submitted. Now, there was a previous application submitted that went through the court system. What happened with that is not relevant to today's public hearing. What we're here to determine is whether this application, as it currently stands, can be approved. And so I think, for the applicant, for the commissioners, for the folks who may be planning to public comment, what's before us today is this application, not any previous application. And so that's where we're at. And I think the more that we can keep our comments and our submissions focused on that, the better off we'll be from a time perspective and efficiency perspective.
All right. Okay, overview for this 4-lot subdivision that we have in front of us
Right,
today.
it's a proposed 4-lot moderate subdivision. What would be lot 1 already has 2 cabins existing on the parcel. Lot 2 has a cabin, and lot 3 has one. The proposed lot 4 just has a shed on it currently. Access comes off of road P.3. It's a deeded access to the property from a developer. Previously, But that is not a subdivision, and those are not subdivision roads. Those are just private roads that were created for access to all the residences in the area.
Red Sign Road, right?
Correct.
They're all red sign roads. Everything off of 37, I believe, to the west. If we're looking at the map that's displayed, everything is a red sign road. P3, P2, P1.
Along
And
with 36.7.
36.75.
36.75 is actually on Mr. Lewis's property.
Okay. Anything else?
That's pretty much it.
Okay. Mr. Lewis, you have the opportunity to add anything that you would like to add. Please-
My question is, do you...
Please pull the mic in front of you so that everybody can hear you, sir.
Like this? Are we good?
As close as
Okay.
you can get it.
Pardon?
As close as you can get it.
Okay. Yeah. Okay, so my question to Mr. Haley is, do you support this four-lot subdivision?
And so it's not about what Mr. Haley does or doesn't support. This is about the commissioners and the land use code. And so, Don, I'm going to advise you not to answer that. It's not your job to support or not support anything.
Fair enough.
Interesting. Well, first of all, let me compliment the commissioners on their past efforts to resolve these issues. Initially, when you all approved the variance for the side yard setback, I recognize, of course, that Section 9103 expressly provides that existing uses, when the code was adopted, are not subject to the same code requirements. And in fact, that was, and no variance was needed because it was exempt. But you granted the variance, and I appreciate that. And I appreciate the fact that that you approved this subdivision previously. The only real issue here is it appropriate for the county to make limitations on the use of my property, conditions, if you will. First of all, which are different from those applied to other property owners. And in fact, are violations, these conditions that have been demanded are violations of the laws of the state of Colorado. Also, violations of the United States Supreme Court rulings. And looking at the codes of the state of Colorado, I refer you to Article 41. Article 41, limitations of actions affecting real property. Okay? First of all, these limitations may be asserted affirmatively or as a way of defense. Section 3841-119, 1-year limitations. No action shall be commenced or maintained to enforce the terms of any building restriction concerning real property or to compel the removal of any building or improvement on land because of the violation of any terms of any building restriction unless said action is commenced within 1 year from the date of the violation for which the action is sought to be brought and maintained. Now, the issue that has been raised by the county regards the house that was rebuilt after the fire in 2016. Recognize that Section 9103 expressly provides that a fire-damaged single-family residence may be reconstructed, rebuilt in its non-conforming configuration, which is precisely what happened in 2016. Now, as we were rebuilding the home,
Now, Mr. Lewis, I think we're getting off topic here. We're talking about homes as opposed to the subdivision application that's in front of the commissioners today. So, you know.
okay, so what I ask you to do is to approve this subdivision without conditions, because the conditions that have been demanded are a direct violation of the laws of the state of Colorado and of the rulings of the United States Supreme Court.
So we put conditions on subdivisions because we have to, and we have not violated any constitutional right of anybody's, as far as I am aware
okay.
of. We have an attorney that sits with us here for that specific reason. So if a condition is put there for access, for water, for whatever the case might be, a condition has to be put on the subdivision.
Oh.
So conditions are placed, and that is not unusual for conditions to be placed. Therefore, if what is brought to us is relevant to a condition, we evaluate it, and then we will or will not put conditions on a subdivision. This is a unique situation that a condition has been placed upon us or given to us to look at. So,
Okay, let's talk about the conditions, because the law is fairly clear here, and the law says this. It's black letter from the United States Supreme Court and from the state of Colorado. Any conditions you place on a development of a piece of real estate are subject to a two-pronged test. Number one, the condition must have a direct relationship to the impact of the development. Secondly, it must be proportional to the impact of the development. Now, what we're talking about here is a new house on Lot 4. Now, in the past, what were the conditions? Do you have those before you now?
I don't have them before me right now, no.
Okay. So one of the conditions was that I put a left turn lane on the highway 1 mile distant from my property at a cost of more than $1 million.
Sir, because development has to pay for itself in this county, turn lanes have had to be put on state highways. That is not unusual. Turn lanes are put on county roads off of state highways. That is not unusual. If the development, the traffic counts are greater than what the current state is, it then triggers something to add more. So therefore, your development, if CDOT, which we don't deal with state highways, that's why we send everything out for responses from the other agencies.
Okay, so what was
the
the
condition is, if you want to develop this property and you want to add more traffic to a state highway, that is within their traffic code. It has nothing to do with us. If the state says you're going to add more, you've got to get more to make the traffic safe, that's between you and the state.
Okay, I'm glad
Let
that
me,
you make
let me
the
just jump
distinction.
in just to focus the conversation here for a second. Don, what conditions did planning and zoning recommend for this subdivision if it's approved?
They did recommend it for approval. The conditions were no new houses be built on Lot 2 or Lot 3, and a plat note pertaining to Lot 4, that if a residence was to be built there, that they need to contact CDOT and get approval from them first.
So,
And just to fill everybody in, at the time this went through the first time, and CDOT advised us of the conditions, we contacted the Board of Realtors and let them know that any properties accessing off of 37, that CDOT has a requirement that they be contacted first before any new residences are built, and we have passed that along. I believe that started in 2021. And so that we can't advise everybody in the area, but anybody that wants to build are to contact our office, and we do relay that information onto them, and that's one of the requirements.
Okay, so first of all, 2 additional homes have been built in this neighborhood accessing the state highway. The county approved it, the state approved it. Now, the real issue here is whether it's appropriate to put language on the plat that requires approval. If the approval applies to the entire neighborhood, then placing that language on my plat is a bold-faced violation of the law, because it's not necessary. If it applies to the whole neighborhood, there's no need to put it on the plat. And it's like I told him early in the game here, as long as you put this on everybody's plat, then that's acceptable. But what you're doing is, and we've already seen that clearly they've acquiesced, if you will, to new homes being built in this neighborhood, accessing Route 30, Highway 184. Already done, approved by the state and by the county. There's no reason, nor is it appropriate, to put that language on my
So
plat.
let me ask you another question then, because now we're on red sign roads. So my question is, these are private roads. The county does not own, maintain, or do anything on red sign roads.
Correct.
You have P1, P2, P3, 36.75 that are privately owned by the people, the individuals that live on those roads. They take care of them. We do nothing. Do you have permission to be on these roads and to add this much more traffic on those roads from these individuals in this subdivision?
Okay, keep in mind that there are 4 houses already
Answer
out.
my question.
Yep.
Do you or do you not have permission on these roads?
Permission to use the roads?
Yes, because
Absolutely.
now you are
Abs-
adding
Absolutely.
traffic. Where is that document?
Okay, I refer you.
Where is the document?
Please. May I?
Where is the document? Answer my question.
The document is produced by the county attorney, specifically
The
addressing
county
this
has
issue.
not
No, we don't
produced
produce
anything.
those documents.
You produced that to us to make a decision. These are private roads. They are red sign roads.
Yes?
Our road stops right up there at 37 in a cul-de-sac, if you look at the map.
Mm-hmm.
Your property's clear down here off of 36.75. We do not maintain these roads at all.
I understand that.
So, you're gonna put more traffic with this subdivision on these roads. Where is the documentation that says, I've got approval from my landowners around me that states I can put more traffic with my subdivision even on these roads?
These
Before
are-
you get to the state highway.
These are easements, public easements, recorded initially when the subdivision was created, incidentally before.
That's not a subdivision there. Those are private lots. Those are not subdivisions.
Terms of art. Clearly, the 40 acres.
No, it's not terms of art. A subdivision, after the land use code, is a subdivision. Prior to that, they were individual lots.
Okay.
So, do you or do you not realize that you are on a private road?
Oh, I realize that these are all
Do
private
you or
roads,
do you
but
not realize you are on a private road?
I answered
Yes or
that.
no?
I'll answer it again. I am on a private road.
Okay,
These, please, these private roads were created by Mr. Gentry when he subdivided this land, incidentally, prior to the adoption of the land use code.
okay. Now
Yes,
you are doing
subdivision
something
occurred.
after the land use code. Do you have the documentation of the landowners there that you are going to, whatever your agreement is with them, help with the road, upgrade the road? I mean, do you have any of that?
I don't need that.
Okay.
Because yeah, I can refuse, I didn't bring the document with me, but I've looked at the deeds that were created, and in fact, Mr. Gentry retained for himself, for his assigns, for his heirs, access to Summit Lake on these roads. It was created in the initial documents.
You are creating something different, sir. You
Yes.
are adding 4 separate lots onto these roads. It's not, what is in front of us is a 4-lot subdivision. That's it.
The
So-
the four houses are already there.
I understand that, but this is a subdivision. This is breaking this up into a subdivision
Okay.
to be compliant with what is there, because apparently the house, and the restriction is that one lot is basically in the lake. Am I saying that correctly? Lot 4, is that why, or lot 3, is that why we have nothing new?
Lot 3 only has a small finger leg that extends southwest of the existing cabin.
And lot 4, looking at the land, where would you put a house and a septic system on there? You're 50 feet from high water line. It's almost, I'm not
Okay.
gonna say anything is not buildable, but you pretty much have struggled to put anything on there. So
Okay.
the question is, a 4-lot subdivision in front of us that was
Sir.
approved by the planning commission with
So,
conditions to move forward.
may I respond?
No, I'm not done yet.
Okay.
You'll respond when I get
Oh,
done. I'm talking
You're
right now.
done? Okay, you let me know when you're done.
Okay?
That is correct. Those were the conditions.
Okay.
Now, they did not restrict Lot 4, only that CDOT had to be contacted, and the planning department would need to receive approval from CDOT
For lot 4.
for Lot 4.
Okay. So nothing new on lot 3 and CDOT requirement lot 4.
Correct.
Okay.
Okay, are you ready for me to respond?
And just to add one more thing, none of the other properties in that whole area are proposing a subdivision. That's why this plat note would only be on Mr. Lewis's subdivision, because we're not gonna go and make everybody redo their deeds with any kind of language on it. We don't have that oversight. Since he is creating a development, it has the review of CDOT, and it requires a plat, and that plat note just refers to contact CDOT for permission.
Correct.
Oh, okay.
I get it.
Now, may I speak?
You may speak.
Okay, first of all, on 2 occasions, CDOT was informed of this proposal. The land use code is explicit. It says failure to respond within 21 days shall be deemed approval. Now, they had 2 occasions to raise this issue. CDOT did. Only after, Mr. Haley, after the 21 days was over, 2 days later, Mr. Haley contacted Joe Heinlein.
This
At
is on the withdrawn application. This is not on the current application.
I beg your pardon?
This does not relate to the current application.
Okay.
CDOT did respond within 20 days on the current application. The other application was withdrawn.
It wasn't withdrawn, it was approved with conditions, correct? I don't think Mr. Lewis withdrew it
Mr. Lewis withdrew.
after the court.
Correct, because he was informed he can't have 2 applications open for the
That's
same
right.
project on the same property. So he withdrew his original application with our office.
Yep.
Now, may I speak? Okay. Joe Heinlein, after Mr. Haley contacted her, sent an email, and the email said, if you build 8 new houses, you are subject to the requirements. Now, please note that they did respond to this application, and what did their response say? That they made no demand. There's nothing in their response that is a demand for CDOT approval. Nothing. It's simply a statement of facts, and the reason is that is the case is because I presented CDOT with the statutory limitations on what they can do. Now, a left turn lane out on the highway, a mile distance from my property, that demand must be proportional to the impact of what I'm proposing to do. And in this case, we're proposing to build 1 house. That will never be proportional. And that is the reason.
That is an argument with CDOT.
Please,
not
that's the
us.
reason that CDOT, if you read what they actually responded to this application, they made no such demand. There simply is a statement of fact. And the statement of fact is that I, in fact, did apply for approval from CDOT, which was actually all I was required to do. I was not required to do anything other than apply. I did apply. The document was prepared in their offices by their personnel.
We are not asking you to do anything on CDOT's right-of-way either. We do not have that authority in our jurisdiction. That's CDOT's. The only thing that we can do is put the condition on the plat that says you have to contact CDOT.
Well, I did
So,
contact
I'm
CDOT.
ready.
So I think
we
at
can
this,
move
I think
forward.
at this point, let's let Mr. Lewis finish presenting whatever he wants to present, and then we'll move it to public comment, and then it can come back to the commissioners for any questions, and then you guys can move forward.
Let me ask you this, will I have an opportunity to respond to the public comments?
Absolutely,
Okay, good.
absolutely.
good
So
start.
write down whatever you want to. When the public comment to speak, you do have that opportunity, absolutely.
Okay, so let's read this into the record. This is Colorado law, is it CRS, is it chapter 29, section 20, section 203, conditions on land use approvals. Quote, in imposing conditions on the granting of land use approvals, no local government shall require an owner of private property to dedicate real property to the public or pay money or provide services to a public entity in an amount that is determined on an individual and discretionary basis unless that there is an essential nexus between the dedication or payment and legitimate local government interest. And the dedication or payment is roughly proportional both in nature and extent to the impact of the proposed use or development of such property. This is Colorado law. This is not a discretionary matter by the planning director or even by this commission. This is the law. Please, let's not ignore that. Now, referring you to Title 29, Chapter 29, 2201. General Assembly finds and hereby determines must be carried out in a manner that is appropriately balances the needs of the public with the rights and legitimate expectations of the individual. This Part 2 appropriately and necessarily underscores and reinvigorates the federal constitutional prohibition against taking private property for public use without just compensation, and the state constitutional prohibitions against taking or damaging private property for public or private use. The General Assembly further finds and declares that an individual private property owner should not be required, under the guise of police power regulation of the use and development of property, to bear burdens for the public good which should more properly be borne by the public at large. This is directly on point to this business on a left turn lane out on the highway. That certainly belongs to, if nothing else, it belongs to all the members of the community, and I believe it belongs right here, you know. And you folks, if I may speak to this, if you want that hazardous intersection addressed, there is a process to do that, and it originates with you. You, this commission, has, if you will, the right and the obligation to the people. As you once stated before, it's a public safety issue, and that responsibility lies with you. Now, CDOT, each year, I've been informed, they receive about 100 applications which are outside their normal budget from the counties of Colorado. Of those 100 applications, I've been informed they usually do 10. I think this is an appropriate act for this body, especially within the context that we now have a fatality at this intersection. Jim Wilson died because that intersection is inadequate. And the responsibility is not mine to fix that intersection. The responsibility lies with you and CDOT. And if I may quote Randy Ryder, of the head of Division 5, quote, "CDOT's not going to do it. The county's not going to do it. I guess you know who's going to have to do it." Well, this is contrary to the law. This is not a discretionary matter. And the obligation lies, it's absurd for you to demand a $1 million highway improvement if I want to build one house a mile away from the road. And you've already, in the 12 years I've been here, there have been a lot of changes in Summit Lake East. There have been 10 new homes constructed. There's been an auto repair business developed. There's a tree service running big trucks developed. And the church camp down there has changed their occupancy. They're no longer occasional summertime users of that land. There are 30, 40 cars in there every single weekend. It's not my responsibility or obligation to fix that road. In fact, there was no requirement for me to even do a subdivision. The claims that were brought by the county were false claims. They made first of all, they failed to comply with the express provisions of the Land Use Code. And the Land Use Code says this: when you become aware of a violation, this is not discretionary. You shall provide written notice of the nature of the violation and the reasonable time to make the repairs. This was not done. This has never been done. This is a very selective enforcement which is improper and which violates the 5th and 14th Amendments of the Constitution of the United States and the adopted laws of the state of Colorado. You're way out of line here. There's no excuse for these demands. Effectively, you deny me the use of my property. To quote Mr. Haley, you cannot do anything on your property that will bring one more vehicle off of Highway 184. What? Does this apply to the whole neighborhood? Of course not. We know that it doesn't apply to the whole neighborhood because we've seen all this development and approvals by the county and by CDOT. So this is a very selective application of these demands. Now CDOT, please look and read what their response was to this application. They made no demands. It was simply a statement of facts. The statement of facts was, it's a hazardous intersection. Mr. Lewis has applied for an access permit. We're not acting on it because he hasn't provided us with a level 2 analysis of that intersection. A level 2 analysis of that intersection cost more than $10,000. I'm already $30,000 out of pocket under bogus claims that were made. This is not right. This is absolutely not right. So CDOT has not made any demands. You read the actual statement, they made no demands as a condition of approval of this subdivision. So let's not ride that pony because that dog won't hunt, if we say in the country. You know, that's a bogus claim. Not right. I'm entitled to use my property. Your demands, which are specific to my property and not applicable to the neighborhood as a whole, are a violation. a clear violation. Now,
Sir, we are only looking at your land right now. We're not looking at anybody else's property. So, are you done? I'm going to open this up to public hearing.
I'm sorry, could you say that
Are
again?
you done? I'm going to open this up to public hearing.
Okay.
The public- In a public hearing, they do have the
Please.
opportunity to comment.
Please,
So-
as regards to your earlier comments about the suitability of building a house on Lot 4, the demand was made that, two demands were made. One was that I do a soils study, which cost several $1,000s. And if you read that document, it expressly states that these are suitable building lots. It's not questionable. Also, Craig Wickstrom, who is the fellow who is the engineer who approves all of these septic systems, has inspected the entire property and has stated that it's suitable to build houses on these lots. It's not a question of is it, it's already answered. Those questions are answered. Do you want to see documents? You have them, he has them. I didn't bring them. I thought this issue was not going to necessarily be raised again because I thought we had answered this. It was done. Okay, so now as regards
You
the red
do-
side roads.
You do realize that you have been approved through the planning and zoning recommendation to move forward with this with 2 conditions. You do realize that, right?
What were the conditions?
They've already been stated. There's no new structure on Lot 3 and that CDOT requirement for Lot 4 notification. It's a notification. We are not saying you have to go build anything.
No. In fact, CDOT does not have jurisdiction over land use. I have their document from Dan Rusin, who's the big dog in Denver. Land use decisions are not for CDOT. CDOT's jurisdiction
I understand,
ends
sir.
at their
Ours
right-of-way.
is with land use.
And
But
access
you access their highway.
Access permits are required for work that is done in the right-of-way. The access permit is inappropriate, is an inappropriate demand for the terms of a 4-lot subdivision.
We are not asking and putting a condition of a requirement into CDOT's right-of-way.
So Commissioner, at this point, I
I'm
think we're
ready to
going in
open
circles.
this
What I would advise is I think we give Mr. Lewis 5 more minutes. It's 9:38 now, till 9:43 to present any new information that he hasn't already presented, and then at 9:43, we're going to go to public comment.
Okay,
Okay, you have 5 more minutes, Mr. Lewis.
okay, are you subject to the adopted laws of the state of Colorado?
We absolutely are.
Okay.
Good.
So then you're subject to Article 41. You're subject to Article 29.
I have an attorney right here with me that can answer attorney questions. I don't study law. I do not. I
So-
don't think any of us here do.
So at this point, 5 more minutes, Mr. Lewis.
So are you going to respond to this and take part of my 5 minutes, or are you just going to shine it on?
You're down to 4 minutes, Mr. Lewis.
You're not going to respond to that?
Mr. Lewis, you have 5 minutes.
Okay, this from Daniel Rosen. CDOT does not approve land use. CDOT only looks to the access on the highway. All right? The engineering's been done, the approval's been done, the demands for a limitation on the use of my property. I have a 20-acre lot. Every other parcel in the county has the option under the land use code to build a second home. And the restrictions that you make on my property must be supported by evidence more than a simple allegation or statement by Mr. Haley or even by you. The law requires that there is a test that you must show that the demand is proportional to the impact of what's proposed. That has not been done. You violated your very own land use code. You're violating the adopted ordinances of the state of Colorado. You're violating the rulings of the United States Supreme Court. The solution is simple. You approve this subdivision without conditions. When you make conditions on my property that are not applicable to others similarly situated, that is a violation. And the law says that this is not a popularity contest. When an applicant meets the requirements, you are required to approve. It's not discretionary. This is not a popularity contest, and it's not something where somebody gives you a phone call and says, kill that deal. So it's still, and I will say this to you, if you proceed with placing these restrictions on my property that are not applicable to the others, that is the very fundamental basis for a constitutional claim, which as much as I despise dealing with lawyers, believe me, you'll be in federal district court wasting the assets of this county pursuing something that is a clear violation. Please don't go there. Let's resolve this today. Just simply approve this. You've already approved the subdivision. The only issue is are the conditions. Number one, CDOT, which is not applicable, we know, even by their own statement. They make no demand. Secondly,
Okay,
is
Mr. Lewis, your time is up.
limit the
It is
use.
now 9:41, and I'm going to open this up now for public comment. So
Okay.
you will get a chance to respond to any public comment if there is any. I will give you that opportunity. So with that, I'm going to open this up for public comment. Anyone wishing to speak for or against this application, you may come forward to the podium, state your name and address for the record, and you have 3 minutes to address the board, and you may address the board at this time.
Is it only on this subject?
Just this subject. We are in a public hearing. If you look at the agenda, it's down. It'll be down when we get done with our public hearings. So this is specific to this public hearing only, nothing else.
Good morning. My name is Ray Boswell. I'm a resident of Summit Lake East and have land adjacent to Mr. Lewis's. The issue seems to me that to have 4 houses on a single lot would violate the land use code. To build any subdivision where the roads are not up to county standards would also violate the land use code, even a 4-lot moderate subdivision. The Planning and Zoning Commission, I think, made a reasonable compromise there in allowing a 4-lot subdivision, but with no additional homes built. It would be, I think, within the law, and Mr. Lewis is very concerned that you follow the land use code, since there are no roads leading to his property that meet county standards of 60-foot easements. Approving any 4-lot subdivision would be reasonable, or not approving any 4-lot subdivision would be reasonable. So to make this compromise of allowing him to have a 4-lot subdivision that would make his lots more sellable in the future, it seems like a reasonable compromise. The concern about CDOT, I think, could be alleviated by the fact that lots 2 and 3, the Planning and Zoning Commission recommended that there simply be a restriction of no new houses built there as part of this compromise. That same restriction could be placed on lot 4 rather than involving CDOT as part of that decision-making process. If CDOT were to change their mind and decide that they would approve additional houses, it would still be in violation of the land use code to put more houses or to create a subdivision there. So to me, it would seem like the simplest thing to do would be to put the same restriction on Lot 4 that you do on Lots 2 and 3. If I decide to subdivide my lot next to his, I would expect the Board of County Commissioners to make the same restrictions on my property. So that's all I've got. Thank you.
Thank you. Next.
So if I understand what he just said, that he doesn't object.
Well, we're in public comment. When I'm done, I will let you respond to them. Until that point in time, just sit tight.
Good morning. My name is Andrea Martin, and I live on P.2, which is one of the roads in question about accessing to this proposed subdivision. I do have an issue with it. That road only has 6 homes on them, 4 of which are on each end and 2 in the middle. That road isn't wide enough to accommodate my F-250 in the wintertime, much less 2 other cars, and 4 other cars, or however, how many houses he wants to build. These roads just can't handle that. In the beginning of talking to Mr. Lewis, I just think this is a fight that's going to continue with this gentleman, because his exact words were to me was that he had all the money and all the time to fight you guys. So I'm not sure what your $30,000 issue is when you have all the money and all the time. He had to sign a petition regarding this exact issue here. He presented this petition along with a letter from 2019 that said that he had 10 days to rectify a septic system, or that home had to be, or those homes had to be torn down. Well, that was erroneous. It was not right. It was a blatant lie, presenting us with a 2019 letter. Those roads are not maintained by the county. They are maintained by us. The people on P1, P2, and P3 all contribute money. Mr. Lewis, have you contributed money for that snow plowing?
No questions.
Okay, sorry. But we all contribute money on an annual, sorry, I apologize. We all contribute money on that on an annual basis to maintain those roads. Mr. Lewis takes it upon himself to take his plow and go out there and dig up the roads and dig up the dirt and dig up the rocks that are maintained there for a reason, to keep the mud down. P1 and P3, which he is, from my understandings in the neighborhood, basically banned from putting his tractor on that, are in perfect condition. I know this. I walk a 6-month-old dog every day, 5 times a day around that lot. And it's my road's the only road that I have a problem with, because until I told Mr. Lewis, please discontinue plowing in front of my house, did this happen. So I don't know where I'm going with this. I do have a problem with him building more homes. I don't have a problem with what Mr. Boswell said. If it's just simply and not adding more homes, go for it. But I do have a problem with more homes going on that property, because it's going to affect me directly going right down my road. And 8 more homes, or however more there is, that's 2 cars per home. That's 16 cars. That's UPS and FedEx and Amazon blowing down those roads. More and more. I'm done, right?
You're done.
Thank you.
Thank you, ma'am. Okay, next. Okay, again, this is public comment for this application of this 4-lot subdivision. Is there any other public comment? Okay, with that, I will close the public comment session of this application, and I will allow you, Mr. Lewis, to respond to the 2 if you have anything that you would like to respond to.
So, do you have a copy of the application before you? Included in that document is a correspondence from Rob Engelhardt. Rob Engelhardt is in charge of the roads and bridges in this county.
That we take care of.
Yes,
That
exactly.
we take care of.
Exactly.
We do not inspect red sign roads.
So
We take care of the green sign roads. The county is responsible for the green sign roads.
Yes, I understand.
Okay,
That's
these
not
are
the-
all red sign roads.
Yes, they are red
Okay.
side roads. Would you please look in your packet and look at the correspondence from Mr. Engelhardt? Would you do that? I don't have that in my hand, but if you read his correspondence,
Okay.
he has no issues. But like you say, the red sign roads are not
He's
maintained by...
responding to the green sign road, 37. His response is pertinent to the green sign road. When it gets off of the green sign road, it does not respond to that. Will the traffic be available on 37 road to support it? His response is yes. On P1, 2, and 3, we do not respond to. We do not have jurisdiction over red sign roads.
I understand.
Please sit down, sir.
I understand that.
Please sit down.
Please
Please sit down.
get in your packet and read what he wrote.
I know what he wrote, and it refers to a green sign road.
Absolutely not. It refers specifically to red side roads, and if you read his statement, it simply states that we make no demands on this road. His recommendation that any roads you create,
And we did not create those red sign roads. It's pertinent to County Road 37, and that's it. We have no jurisdiction outside of that road.
okay,
We do not take care of P1, P2, P3.
So-
Those are red sign roads.
Gentlemen.
It doesn't matter. Wait.
please.
Just give me a second. So, do you want to respond to these two, Mr. Boswell and Ms. Martin?
I appreciate your acknowledgement that you have no jurisdiction over the red sign roads. Therefore, you have no jurisdiction over the access over the red side roads. Only the green side roads are under your jurisdiction. You have no
access
say
road-
under, by
you
your own
access Road
admission,
37.
by your own admission, you acknowledge you have no say over the red sign roads. In fact,
The land you, okay, are you done, sir?
I doubt
Because
it.
Have you, well, I doubt it too, so, but we do have to go on.
Okay,
So,
so I ask you
I'm going to
to...
bring this back to the commissioners, because I think we've heard everything that we're possibly going to hear, and I don't think it's going to go any further. Commissioners, do you have any other questions or comments at this point in time?
Don, on those roads, are those actually a dedicated access? Or those property owners still own to the middle of that road? They're up and down?
So the only documentation I've seen is, and from what I've been told, we don't have those, Mr. Lewis did not supply that, is that those are dedicated roads to each individual lot. They're 30-foot wide easement. As far as anything beyond that, I could not tell you. The GIS map shows their property ending outside of that 30-foot easement with no known owner of those roads.
Of the property under the road?
Correct.
May I?
What were the recommendations of P and Z? Again,
That no new houses be built on Lot 2 or Lot 3, and that a plat note be put on the Mylar, that any proposed residences to be built on Lot 4 to contact CDOT for approval.
So, so commissioners, if I may, I think one of the big issues for you guys in making this decision is that those roads are very undefined, what they are. There really hasn't been information supplied as to who owns them or how wide the easements are. From what I can tell from reviewing the documents, it appears that they're 30-foot dedicated right-of-ways. The land use code, specifically section 5305.5, talks about roads in subdivisions. And it says, in all developments where streets or roads are intended for use by the general public, by lot or unit owners, or by anyone other than the applicant, the preliminary plan shall meet the Montezuma County Road and Bridge standard specifications. Those specifications are 60-foot right-of-ways. Now, what that section of the land use code certainly pertains to is a subdivision similar to Mildred Estates, where you've got roads running inside the subdivision. That's not exactly the case here, because these roads don't run inside Mr. Lewis's subdivision. They provide access to Mr. Lewis's subdivision. So the code isn't directly on point as to what happens in situations where the subdivision itself is being served or accessed by roads that are not up to the county specs. I mean, I equate it to, there's a lot of roads in the county that may not be 60-foot right-of-ways. Just because your property that you wish to subdivide is accessed by one of those roads, it doesn't mean you can't subdivide that property. You see what I'm saying? But certainly if you subdivide that property and you do multiple lots, and anything inside that subdivision to access those properties must be up to road and bridge specifications. All of that said, the land use code is very clear. Section 1201.2, it says that subdivisions must have approved CDOT or county access permit. That is absolutely the case. In this case, CDOT has not approved an access permit for this subdivision. Now, I think it's an interesting question whether or not CDOT, where CDOT stands on that, and I think that's really in CDOT's court, whether they can approve or disapprove an access permit per their highway access code. But that certainly is required by our land use code. And so I think that the restriction that has been recommended for Lot 4, that no new homes be built absent CDOT approval, I think that's perfectly reasonable in light of the land use code. Now, what CDOT can or can't do, that's really up to CDOT here. And that's something that Mr. Lewis is going to have to take up with CDOT. The restrictions on Lot 2 and 3, the no new buildings, I think that conceivably could be justified by the fact that these roads are fairly small. We just had testimony during the public hearing that the roads are narrow and it's difficult to access these properties. And so is it appropriate to add more traffic to those roads? Maybe not. And maybe that's the ground that you use to put the restrictions that the Planning and Zoning Board recommended. I think certainly the CDOT restriction is completely reasonable and could be applied to all of the lots in this subdivision. It's really been applied to all of the lots in the entire subdivision. Nobody's supposed to build out back there without CDOT approval before building at this point. And so that's where we stand.
Okay. All right. Back to the commissioners then, gentlemen. We basically have a recommendation for a 4-lot subdivision approval with the restrictions of no new structures on lots 2 and 3, and that lot 4 have a CDOT requirement notification prior to structures.
May I speak?
So, any other questions?
No. Gerald, you have anything?
I don't know. We require this access being 60 foot to everybody else's subdivision in the whole county. When everybody else comes through here, they're required to have that 60-foot access. I think that's a critical part of making sure that we have the proper roads and everything else in this county, because what happens is down the road, on all 4 of these lots, people that end up buying them are wanting to know why they don't have a better way to get access to their property. And that's what happens. They all come back in here wanting to know why we allowed this subdivision to happen without proper access to it. And that's what happens down the road in the future. just to, seen it happen for years. Same thing. Whether it's the water, whether it's the roads, whatever. It happens the same way every time. Down the road in the future, the people that own these lots are gonna be back in here wanting to know why we approved this on these little narrow roads.
And so along those lines, I mean, if that, and that's relying on 5305.5 of the land use code, then this application should be denied, not approved with conditions.
Yes. It's my opinion. I don't think we can approve this type of subdivision when we put all these requirements on everybody else to have these things and do it right. I don't think we should be approving one where the roads are inadequate at this time.
And along those lines, I mean, in addition to this specific provision, Commissioner, that you've cited, there has been evidence presented today that it's difficult to access the properties back there as is, given what lays on the ground. And that goes right to that and this issue.
Gentlemen,
Yes.
may I speak?
When we get done, you will have the opportunity to speak, sir.
Okay.
We are conversating right now, and when we're done, again, I will give you the opportunity.
Thank you.
So I have a question then, because he's out of compliant. If we don't approve the subdivision, he's out of compliant anyway, because he has 1, 2, 3, at least 3 houses. Is that correct? And then we have
There's 4.
4, so the lower one is a house also?
The
So-
bottom right one is just a shed. There's 2 on the lot 1, 1 on lot 2, and 1 on lot 3.
There's a
So-
little shed on 4, I think.
Yeah, gotcha.
Correct.
So we're still out of compliance with the land use code because he's done things since the land use code's adoption in the late 90s. Okay, it was just a question. All right. Anything else, sir?
No.
Okay,
Now-
you may have the opportunity.
Okay, so regarding the 4 houses, the land use code expressly provides that situations in place when the land use was adopted in 2020 are grandfathered. They are not subject to that restriction of 2 houses per lot.
It was not adopted in 20.
Well, it was,
It was adopted in the 90s, the late 90s.
well, actually, the original one was 1972, I believe, if you look back through the record. In any case, the 2020 version expressly states that conditions existing at the date of that adoption are grandfathered. So those 4
So-
houses are clearly grandfathered, as has been admitted by the county planning director.
Okay,
And those 4 houses are not in conflict with CDOT or any laws whatsoever. Now, if you look at this subdivision map, you can't see it there, but as Mr. Haley acknowledges, the entirety of Road 36.75 is not on the granted easement, rather it is on my property. So as part of there's a 30-foot easement on the other side of the road, on the east side of the road. So we have 30-foot easement there. In this application, I'm dedicating an additional 30 feet. So we have met the statutory requirement for a 60-foot road right-of-way. It's not an issue to hang your hat on here, because you have a 60-foot right-of-way. It's a done deal. With the approval of this 4-lot subdivision, you have 60 feet of right-of-way. We've met the code. So don't pursue that as a basis for this. Furthermore, these roads have been in place for 40 years. They were created long before the adoption of the land use code. They are clearly grandfathered. Now, keep in mind that the county commission granted a variance for the less than 30-foot setback. They granted a variance for the location of the home we created to to replace the fire damaged
We're
home.
not talking about a variance right now, sir. We're just looking at this subdivision. So I'm going to go ahead and bring it back to the commissioners, gentlemen. What's your pleasure? I think we've heard everything we need to hear.
I already stated my position. I mean, I don't think we can, personally, I'm not voting for this.
I agree with
be-
Gerald.
To be passed because
So then this
of all
is
the
a
things I
denial?
stated a while ago,
I'll move it. I would so move that we deny this permit based on inadequate access and the lack of a CDOT approval at this point. Anything further?
Nope, I don't think so. I mean, those are the 2 points. I mean, Commissioner Copenhaver made the point that the access was not adequate. It is not up to county road specifications. The point was also made that a CDOT access permit has not been granted, and CDOT has commented that the applicant is in the process of applying for that, but that has not been granted. It's not in the application packet, and so I think that covers it, Commissioner.
second.
Okay. Been moved and seconded to deny this proposed four-lot moderate subdivision and rezoning application submitted by Ellis Lewis on property located at 14171 Road 36.75, Mancos, Colorado. Any further discussion? No. All those in favor?
Aye.
Aye. Okay, sir, you have been denied.
Okay, I'll serve you with the document here momentarily.
You will do what you need to do, sir. Thank you. All right. It is 10 o'clock. We have our next applicant.
Yes, we do.
Good morning. Okay, this is our second public hearing continuation from December 5th, 2023. Would you call the roll, please, Kim?
Commissioner Candelaria.
Here.
Commissioner Lindsay.
Here.
Commissioner Copenhaver.
Here.
Administrator Anderson.
Here.
Attorney McLaren.
Here.
And Kim Purcell, Montezuma County Clerk and Recorder. Notice is hereby given that the Montezuma County Board of County Commissioners will hold a public hearing for a review and determination regarding a proposed four-lot moderate subdivision and AR 3-9 and AR 10-34 rezoning application submitted by Braden Jones on property located at 38511 Road H, Mancos, Colorado, consisting of 26.29 acres more or less, located east of Highway 160, north of Road H, situated in Section 36, Township 36 North, Range 14 West, N.M.P.M. The hearing will be held Tuesday, December 19th, 2023 at 10 a.m. in the Commissioners' Hearing Room, Montezuma County Administrative Offices, 109 West Main, Cortez, Colorado. Interested persons may attend and give input. Information may be obtained from the Planning Office online services at https://co-montezuma-co.smartgovcommunity.com public home. You may also contact the Planning Department at 970-565-2801 with questions. Dated this 14th day of December, 2023, Kim Purcell Clerk, Board of County Commissioners, Montezuma County, Colorado. First published in the Journal on Wednesday, November 22nd, 2023. And this is a continued public hearing from December 5th, 2023.
All right, thank you, Kim. And I do have to stop for 1 minute just to pause to go back and close the last public hearing. I do apologize for that, but that last public hearing is closed. So with that, I will bring it back to you, Mr. Haley, and you can give us an overview. I know the continuation here, but go ahead and give us a brief overview again, please.
Right, so the owner, Mr. Jones, is proposing a four-lot moderate subdivision on County Road H, just off of Highway 160. There's a current residence and guest house on the west property that's existing. That's the 12.5 acre parcel, and he is proposing to create a 4 acre, a 4.5 acre, and a 5 acre lot.
Okay, and
Access would be off of H where the black line is. That's a 60-foot easement for access and utilities, and would access the 3 new lots.
Okay. Mr. Ireland, would you like to respond to anything?
Yes, sir. I'm purchasing the southeastern lot. I've acquired a water tap for that already. It has been paid for and approved. The intention is for the central 4-acre lot. I believe he's in negotiations with selling that for agricultural use to a local nonprofit. The Four Corners Food Coalition has indicated they would like to purchase that to grow vegetables. The northeastern lot, I am planning to purchase that probably a couple years down the road. I just don't have the finances to acquire everything right now. So with plans as they are, there will only be one residence put in, and that tap already has been acquired for said residence. I do have a statement from Dave Johnson at Mancos Rural Water stating that while there are other taps available in the county, they would have to be approved on a case-by-case basis. I know Dr. Jones has been in contact with a few individuals that have taps for sale, but there's a question if the 2-inch main can handle that burden. But with the current plans, there is no need for any additional taps.
So, this is interesting because, I mean, just because there's not plans, I mean, you have to have utilities to serve the subdivision, and based on this, I mean, it sounds like that's not a guarantee at this point, if I'm reading this correctly.
Mr. Johnson also indicated that if there was a determination they cannot handle that increased burden on that 2-inch main, if an additional tap is needed, that a cistern could be an option as well.
But the cistern, again, is served by a water dock, and that's not a reliable source of water at this point.
So, I think we expressed this the last time you were in here. Our concern are the finite resource of water. Mancos specifically in this area, although you could haul water from, out north of town, Cortez, even Dolores, because they don't restrict it, but Mancos specifically in their water dock has asked us to be very cautious of what we approve, and because the finite resource of water in Mancos area, they don't have, and they're going to try and limit it to their township. So it would not serve this. Now, it doesn't mean that you don't have the potential to haul water from someplace else. It's, I'm going to say at the very least, very difficult for us to, a cistern is permissible, but it's tough to really call that a patent resource. So I think that's what we were asking last time, was for the documentation to say that you had water taps available for these 4 lots. And it says it's only specific to 1 lot. So,
Do you know how many other taps are on that line, by chance?
I do not have that information, sir.
Okay.
I apologize. That was not anything I was asked to get, but
cisterns are permissible, correct?
Correct. It states that if the source of water, if there either is not a water line or there's water not available in that line, then a cistern is permissible.
But there's still, go ahead.
But there still must be reliable water. And I think that's the fundamental issue here. Right now, there's no evidence of reliable water to serve this. I mean, you could put a cistern, but you still have to fill it somehow.
Is Mancos the only water dock? No.
No, Cortez has one, Dolores has one, Montezuma Water Company has. I know at least one out in the Pleasant View area that we serve, but I don't know if they have any others at this point in time. Okay.
What was the recommendation from P&Z?
They recommended it for approval.
We've already had a public comment on this, so I don't have to do that again, do I?
Well, I mean, we received public comment in the first hearing. I don't think there's any harm in opening it up for public comment, but I don't think that, I mean, we obviously consider the public comment that we received in the first hearing, so I don't know if there's anything additional that we didn't receive in the first hearing. I don't think it would hurt to open it
Okay.
up, but what we did receive, we've considered.
Okay, well then, I will go ahead and open this up for public comment. Again, this is for this application only. This is for a 4-lot subdivision. So anybody wishing to speak on this application, please come forward to the podium, state your name and address for the record prior to providing your comments, and you may address the board. And also, you have 3 minutes.
Jeanette Dillon, 38808 County Road H. We're in the neighborhood. I want to address a couple of things. At the first hearing, when P&Z was in support of this, and they stated that, that Mancos was building a new water storage tank, and that Mancos was putting in a lot of lines, those things were truths, but they weren't truth to this particular case, as all the new lines they're putting in are for a huge development, supplying water for people up at Jackson Lake. Has nothing to do with that, yes, we're gonna open up more water for the people of Mancos. It's a very specific project. And I felt like that information was presented to you in a way that didn't give you an opportunity to make the correct informed choice about that information. So I just wanted to clarify that those things do not pertain to supplying more water to this project. Also, in speaking to Dave Johnson at the Rural Water Office, he stated that our road has a 2-inch pipe. It's one of the most limiting sizes in the Mancos Valley, that 2-inch pipe. They're old, it's very small. So even on our end, he was shaking his head, he didn't like it because he feels that it's not adequate to serve those 3. And he said he's not going to approve any water. He said in the summertime, we're running at, I believe it's 300 gallons per certain something, and he said in the summertime, that basically is at capacity for servicing water in our community. So we all know that there's a real problem with water there, and I feel like our neck of the pipe in the Mancos Valley is even more limited because it's a 2-inch pipe. So those are the main things that I think that we need to be concerned with is, if we approve this today, but there's not water for all 3 of those, I mean, you never know. Yeah, these people might use it for agriculture, but they might want to put a bathroom on their ag property if they're going to do gardening there. So I do think we need to consider those facts and the way that they were presented last time as well. Thank you very much.
All right, next. All right, seeing no further public comment, I'm going to close the public comment section of this application, and I will bring it back to the commission.
And commissioners, let me just give you a cite to the land use code real quick because I think it's very pertinent here. Section 5101.3, subsection G, it says water supply. And it says an adequate supply of potable water shall be available to each lot in a subdivision. Subdivisions that are served by existing rural or municipal water systems require a formal commitment of water service from the appropriate water supplier and the installation of water lines by the subdivider to the boundary of each lot. Subdivisions to be served by the development of an on-site treatment plant must also comply with public health regulations. If the proposed development involves well water, then permits from the state shall be permitted. Cisterns are only allowed in the event that a potable water supply is not otherwise available and may be installed by a lot buyer. And so that's what it says. I mean, that certainly seems to suggest these lots are served by the rural water supplier, if I'm correct. And it's just, there's no commitment at this point in time.
Any other questions, gentlemen?
So can we create a 1-lot sub?
I don't think that that's what's been applied for, and so no.
I know that's not what's been applied for, but it's just.
I would suggest if that's the route that's going to be pursued, then a new application be submitted for that 1 lot to be subdivided.
I think that would be the best thing in my mind, to go back, and then if if they decide to do the other lots whenever there's water available, they can do it, come back forward with it. That's my opinion.
Yeah, I don't think you're gonna get more availability of water unless you upgrade the line.
Yeah.
I mean,
The
that's,
whole line will have to be
that's the
upgraded.
whole
Yeah.
premise of this entire thing. A 2-inch line only has X amount of water, period. I mean, it's not, we can't push any more through it. However, a cistern is, this is the deal that we've had this conversation before.
I think the difference here is that this is served by the rural water district.
It's only served to the point where they can't serve it, though.
Yeah.
Therefore, being a cistern, and the cistern is permissible, that's what I'm hung up on.
Yes, there's a water line there, and if those lots aren't sold or nobody builds for 5 years, Mancos Rural Water might upsize that line to 4 inches. And then it would be available. I don't know, I can't interpret it for you. I just know that it says if that water line can't serve it, then a cistern is available as an option.
So, in front of us is a 4-lot subdivision with a letter to us that says that there is availability of 1 tap for 1 lot at this point in time, and the others are on a case-by-case basis. But with that, gentlemen, that's what we have to base our decision on today.
We can't, I asked Ian, we can't restrict further sales. We can't put a contingency on those other 3 lots that water be available. So that's, I mean, we're kind of stuck.
And it does comply.
It does.
Okay?
Gerald, you have anything?
Well, the old original lot they have a tap.
Yeah.
Right.
That has a tap. So, and he's got a tap there. It'd just be for those other 2 lots. I don't,
The other 2 are the only ones in question. He does have one purchased
Correct.
per the letter that's been provided to us. So there are two
Correct.
taps that are
Eric
going to
has
serve
purchased the second one.
those 2 lots. And we do have a 60-foot easement. They could put in a new pipeline up there and maybe upsize it too, off of that 2-inch main. I mean, they're
It's a difficult situation because, I mean, the land use code does say that cisterns are available or are allowed. But, is there a reliable source of water given what's going on? I mean, it's
Isn't that up
It's
for
questionable.
Mancos Rural Water to determine?
seemingly
They
so.
can either sell a tap or people could build a cistern.
and you can haul water from anywhere in the county.
Yeah.
Okay.
I don't know. I think this water thing is so crucial that I think I think when that's stated in that land use code, if that water's there on that road and and that service is possible to be there, then I think that takes away the cistern thing, in my mind.
And I think that's a reasonable interpretation. I mean, I think the overarching spirit in my mind in reading the code, and I mean, certainly there are different interpretations could be had, but the overarching idea is that if a rural water district serves a piece of property, then you can't subdivide that property if there's not water available from the rural water district.
And the rural water district was not, I mean, the letter just says on a case-by-case basis, they would not tell you that there was availability of water for 2 more taps?
They would not give us that information, but he was more than forthcoming saying that if they could not provide that water, a cistern could be made available. That's what he says in his last statement in the letter, yeah.
Yeah, I read that. Which then is compliant with the land use code. Okay,
But if things progress as anticipated, there is not a need for those other 2 taps. Like, my lot will be increased to a bigger lot in a few years when I can apply to make that subdivision, and the other lot is primarily agricultural use. There's no plan to be more than 1 residence in these 3 lots that are being subdivided.
My recommendation would be, I mean, not just for this, but in moving forward with these subdivision requests. I mean, I think if there's not water available, then you've got to retool your application, and there is water available for that 1 lot. I think the cleanest way would be to come back and ask for that 1 lot subdivision at this point in time, and then, you know, as water becomes available or there's a firm commitment, then at that point in time, then certainly further applications could be brought.
So, let me ask you this, could we put the restriction on there for the 1 lot as an agricultural purpose only? Or not, because it is in a
I
subdivision?
think once you start to put those kind of restrictions on a piece of property, you're heading down a bad path.
Okay. Well, this is, I wish I was an attorney sometimes sitting up here, and I'm not an attorney by any means at all. Because it's all about language and interpretation, and how do you read this, and how do you read that, and it's so convoluted that it's an actual mess.
So,
challenging.
go ahead, Eric.
I was just commenting, nothing important.
So, I don't know where this is gonna land, but as an option, if this was only to create 1 additional lot, and that's a lesser impact than the proposed 4 lot, and P&Z was recommending approval of the 4 lot, is it conceivable that you could amend the application now?
No, I don't think so. I think if you're applying for a 1 lot, that's a whole different analysis, a whole different set of circumstances, and I would recommend that if that's the application, that application be brought, that be considered by P&C, and then that be brought before the commissioners. I mean, obviously, the commenters that commented, they're commenting on the application, what's been submitted to us, not something different.
It's almost foregone, though, that P&Z is going to recommend a 2-lot moderate versus a 4-lot moderate. So, I mean, it's a matter of going round and round and round.
Yeah.
We're already to the point where this is a lesser impact. It addresses the water issue without putting the applicant through the process that's, I don't know.
And certainly common sense would dictate that would be available, but there's nothing in the land use code that contemplates partial approval of these applications in that sense. Oh, we're going to approve this lot and this lot, but not this lot. I mean, that's just not the way the land use code's drawn up. I mean, that's not what's been submitted to us, and so.
There goes government getting in the way of common sense again.
So what's in front of us right now is a 4-lot subdivision, and I get what you're saying, Neil. I mean.
Well,
Anything else?
I just don't think we can approve this personally the way it is without that water for those lots. We had these presentations of subdivisions before when I was here, and they were turned down for the same reason, because there was not enough water available in Mancos Valley to supply those, for them to put in subdivisions
You making that a motion?
in the past. Yes, I move that we deny this application at this time.
I'll
Due to the
second
fact the water's not available to 2 of those lots.
For water availability?
Hmm?
For water availability?
For water
Yeah.
availability.
Even though it says, so I've got discussion here,
Yeah.
because I'm not gonna, I mean, I still have the comment here. Even though the land use says that they cannot supply it, a cistern is available.
Yeah.
A cistern can be utilized. That's my issue, is I think that if we don't, I mean, I understand absolutely what you're saying, Commissioner. And I worry about this because in today's day and age, nobody wants to haul water or have it hauled or pay to have it hauled or whatever. However, that still is in our land use code, and it, read it again for me.
I think that the motion that was made is based on this. It says subdivisions that are served by existing rural or municipal water sources or water systems require, that's the word that's used, require a formal commitment of water service from the appropriate supplier and the installation of water lines by the subdivider to the boundary of each lot. And then you go down and it says cisterns are only allowed in the event that a potable water supply is not otherwise available and may be installed by the buyer, by the lot buyer. And so that word require, I mean, these lots are served by the rural water system. I think that's the distinction.
Okay, so it's been moved and seconded to deny this proposed 4-lot moderate subdivision in AR 3 through 9 and AR 10 through 34 rezoning applications submitted by Braden Jones on property located at 38611 Road H, Mancos, Colorado, for the conditions of water availability served to the 4 lots.
Yeah.
Any further discussion?
I don't have any.
Okay. All those in favor?
Aye.
Aye.
Aye. I think where you're at now is to come back with maybe just a 2-lot split because you have required water from the rural water company. Or get them to give you something that's patent that says they can't really supply it.
Understood. If he proposes the 4.1 lot to be for agricultural use only, will that still have the same bearing?
So I wouldn't comment on that at this point in time. I mean, an application can be submitted, and that's something that you guys have to consider when it comes before you. We can't give advice as to what to submit and what not to submit.
All right, so I think okay.
And just for clarification, like, everything we did here was in compliance with the land code, but just due to verbiage or interpretations, you're agreeing that we need further clarification about the water.
Because of the requirement for the patent water supply, it does not meet the land use code.
Okay, I was.
Because Mancos Rural Water does serve that area, and if they're saying by letter that they can give you 1 tap, and he wasn't willing to give you 3, that makes it totally different.
Even with his statement that a cistern could be an option, that doesn't apply? Understood?
Yeah. Okay, all right. Anything else? Okay, I will close this public hearing.
Thank you for your time, gentlemen.
Thank you. I'm gonna take a 5-minute recess down before we jump into signing these, and then we'll come back as you get those things all rolled out. We'll be back at 4:40, or I'm sorry, 10:39. Back to 10:39, our 5 minutes is up, so we will reconvene. All right, Don, it looks like we have three more issues here with planning. I think we discussed item number 1 yesterday. I think we have the direction on that one, so we will kind of move forward in that direction, correct?
Right, so we would like to request a public hearing scheduled for January 30th at 9 a.m. for the review of revoking the certificate of designation from the property formerly owned by 49 Square Ventures.
Okay. Do we need formal action on that, or just the direction of?
We don't need formal action here. We can just go ahead and, why don't you just set a public hearing for that date, and then we'll
Okay.
just notice it.
All right,
So
so
just-
then I will, Commissioners, do you have any issues?
No.
Okay, we will set a public hearing on January 31st, 2024.
30th.
Oh, 30th, sorry. January 30th, 2024.
Correct.
To discuss the certificate of designation for 49 Square Ventures because it was sold. Okay? All right, very
thank you.
good. That takes care of item number 1. Item number 2.
Our next 3 items are signing documents,
Okay,
high-impact permits, and an after-the-fact variance.
so we have 3 documents to sign?
Correct.
Okay.
This ought to be interesting.
Get your timer ready.
Getting there. We're ready. What do you want to bet he didn't stop at 3 minutes?
Well, I guess the only other question I have, since we're talking about CDOT and access permits, if you had a meeting and had a discussion on 184 and Road 25? Not yet.
No, at the TPR meeting that was held on Thursday, I was obviously gone on vacation.
Oh, that was last
We
week.
did not have a quorum, so there were no items to address that could have been taken care of at that point in time. So it'll be at the next TPR meeting before we can address anything.
Okay. Fair enough. When is that meeting? Is that in January or is it quarterly?
February, I think.
Okay.
I can find out for you
Well, that's fine.
for sure, but I want to say
Just if you can have it on the agenda for that discussion and see where that's headed.
Yeah,
That's a bigger mess.
right at 25 and 184.
Correct. All right.
Everything that we have exiting onto CDOT's highways are getting more and more complicated.
Yeah. And just for everybody's information, we have already signed 2 waivers, 2 individuals that applied for access permits from CDOT, both on Highway 145. So this isn't something new, it's something that CDOT started last year, and I'm sure it's going to continue. They would prefer that we get an access permit for every county road accessing their highways. But that's just because they want to push it off on the county and not take care of it themselves. So I don't know what the future holds there or what discussions we need to have moving forward with Road and Bridge and how that's going to come about.
I think it's a discussion with CDOT for sure.
Right.
And then to figure out how any future growth or development is ever going to take place if it's not already on an
Right.
AC/DC lane. Just because of traffic increases on the roadways.
Right, because there's several of our county roads that already exceed their limits on access without turn lanes, and that's not because of any specific development. It's just our continued growth in the area. So I'm not sure who gets the bill for that. Because if it's already exceeding their limits, and they didn't address it, and they did all these new overlays and approaches and everything, seems to me they've dropped the ball. But that's my one-sided perspective.
I know there's not enough funding in the state of Colorado for all of the roads and all of the counties that they are taking care of right now, and that's always a conversation, whether it's at our own TPR or whether it's at the State Transportation Advisory Committee that we
Sure.
we also sit on at the state.
Yeah, I mean, it was really necessary at P and N on 491, but that was simple, with striping, and they had
Right.
shoulder space. Some of these others are
Not
major
simple.
configurations, so.
Yeah.
All right,
Okay,
that's all I got.
thank you guys.
Thank you.
All right. Now, this is moving on to public comment, and this is open public comment, not specific to any application. So the Board of County Commissioners welcomes you to this meeting. Person speaking during public comment will be limited to 3 minutes, or depending on the number of people wishing to speak, it may be reduced to allow all members of the public the opportunity to address the board. When addressing the board, please state your name and address for the record prior to providing your comments, and comments to individual supervisors or staff are not permitted, and participants may not yield their time to others. With that, the public comment session is open. Come up to the podium.
Tell me when you start that watch, because I want to make sure I get everything I can in there.
As soon as you start speaking with your name and address.
All right. Obviously, this county is having an explosion of
Name
growth.
and address.
Name and address.
Oh, okay. My name is Edward P. Anderson. I live at 24907 County Road M. I've lived here for 15 years, and I do love and enjoy this county. So I'd like to address you guys because I feel that you're going to make a vital mistake in your budget since you have not been clear with it. And I believe Travis Anderson has been a failure in his job.
So you cannot,
You cannot
this is
address.
public comment. You're addressing us, and you will not, participants will not address individual supervisors or staff are not.
Can I
permitted.
address the administration?
You can address us, the
Okay.
commissioners. This is public comment.
I'm addressing you then. I feel that this county's failing for healthy growth. And I think considering cutting 7 sheriff jobs for this county is a big mistake. And if that sacrifice is to be made, I think you guys should sacrifice your paycheck. This county is beautiful and it needs to stay that way, and it's getting ugly. We've had a lot of shootings in this county, and I think you guys need to be clearer with your budget. Upping the administration's wages by $40,000 and cutting active sheriff jobs is a big, big, big mistake. And there's evidence of it a few weeks ago. And I feel our county could do better, it could be better, and it could protect the health and growth of this county. I believe making someone else's job easier and taking other jobs away is inappropriate. And I mean the administrator's job money-wise, and then taking sheriff jobs. I don't understand that. My other comment is the powers that be of this county are blind to see. You guys need to open your eyes. The writing is on the wall. This county is getting sick. It is growing faster than it can maintain it. It's getting a little bit big for its britches. And let's see, what else did I want to say? I really think you guys should consider your job, maybe put more passion in it, because I think law enforcement is the stability of this county. It's the foundation of a good home. And for the administrators to even think about cutting it, I think they should cut their wages, not raise their wages. And I think maybe the county, it's time for us as a whole to maybe pay taxes, more taxes, to support that. And I know that's not what people want to hear, but I think it's a real thing. And I think you guys need to get more creative and innovative with your budget, because you've had people that had a passion. My wife was one of them. She's let go. She had a passion for the weed invasive unit. You had an economic developer you let go. These are people that protect the health of this county. And it's just like the weeds in your yard. If you don't maintain it, it gets out of control. Your budget is going to be that. You need to be clear.
Thank you, sir.
That's all I got to say.
All right, next.
Good morning. Alan Mays, 21693 County Road 21 in Lewis. So the budget was addressed with that last speaker, and I know you are going to have a hearing, or you're going to discuss it on January 2nd, what you're going to approve, apparently. The budget is going to be made available to the public, and so I will be looking at it. I hope emails, since it's going to be addressed first thing on the 2nd. I don't know if public comment will be taken during that decision. But anyway, if emails can be after reviewing what the budget is, I agree that the county is needing to look at where money can be saved, how it can be better used, and so I appreciate that you guys are really looking at that. I want to address something that the last speaker did say about public safety and taxes. I know that that is going to be something that's going to be addressed by you guys even today. And so any kind of new taxes have to be considered, how they're going to be drawn from the county and how they're going to be utilized. So a good plan is going to be necessary of how much money is going to be taken from the landowners, taxpayers, everyone, and where that money is going to go. I did listen to your workshop yesterday. I heard some good comments that does have to be the plan. Look at where the money's going to come from, how much is going to be addressed to that slice of pizza that I buy, or whatever it might be, and then how specifically will that be used. It's going to need to be very transparent to the public how that money will be utilized. We don't want it to be like the state where they put it into the general fund. We're going to use this money that we're gathering for education. They put it into the general fund, and then they say, well, we came up with something different that we had to use that money for. But public safety is an issue, and so we know that we have to do better here in Montezuma County in that regard. So thank you very much.
Thank you. All right, next.
Otis Sykes, 19250 County Road 15, Yellow Jacket. Can I give y'all my card? That'd be all right? I think Kim already has one. Gerald knows where I live.
Thank you, sir.
came here about 2 months ago and I asked a question about, do we have a contingency plan for any kind of terror activity? And I didn't get an answer. And let me say this first. Anytime I come here with stuff like this, I'm not coming here just for me. I'm coming here with questions people in the county have, okay? This is not just me. I asked a question last time and I didn't get an answer, but this time I'm going to ask some questions and I'm going to get some answers. People are concerned about illegals. They know they're here. We'd like to know if they're sponsored by anybody in the federal, state, county, city government. Any funds going to any illegals, housing or feeding illegals. Because if they're here and law enforcement or people in authority know about it, they're breaking the law and law enforcement's breaking the law. If we know and we don't do anything about it, then we're breaking the law. So, we'd like to know, are they here? Do we know about it? And we want some answers to those questions. And this time, I'm not going to take no for an answer. I'm going to get some answers to these questions. Are they sponsored by federal, state, county, city government? Are they funded by, fed by, housed by? We'd like to know those things. And anyway, I appreciate the time.
Thank you. Okay, next.
Good morning. James Myers, 41777, Highway 184, Mancos, Colorado. And I would motion that we make Christmas every day, and we only allow to be mean and obnoxious to each other one day a year. But besides that, I do agree with the gentleman just recently about law enforcement and how they should be held accountable for their acts and actions. There is some mailings to the 3 council members, and in compliance with 2410-109, I am seeking for damages for what's happened to me. And I will cite that in Warren, Michigan, a man is facing 8 years in prison for the crimes I witnessed. And I was arrested in this county by your sheriff personally to cover it up. I've talked to many attorneys. I have a lot of great respect for some attorneys, because most of them are very honorable. But right now in your county, you have a alternative defense counsel that somebody's paying for. There's now altered court documents, graded court documents, and is just kind of having a willy-nilly way with her courthouse over there. With so much fraud, there's so many torts in that court going on right now that this will have to go to federal. So I have asked for some resolution before. Meth Mountain is going to be renamed. It's going to be Harmony Hill or Meditation Mountain, because you have now in this county civilians that are acting as prosecutors in your court system, prosecuting felonies. That's very unusual. I've asked for help before. I've had to march your sheriff off the property because of his obnoxious conduct on property. And I've had to ask Officer Copeland to leave property too, because his threats and intimidations are what got me arrested. And his threats or intimidation is why I backed off of some of the lawsuits that have been filed. You have law enforcement going around acting as thugs, threatening and intimidating people. And the fact that they arrested me and held me in the manner they did and denied a lot of my rights, I am asking for some type of resolution, because this can be fixed. Appreciate you guys this time.
Thank you. All right, next. So before you leave, sir, I want to address something for you because now it's my turn to talk. And you made a statement that I just want to clarify, make a clarification. You made the statement, it's not a debate. You're not going to respond. I'm just going to talk.
Okay.
You made a statement that it was our sheriff, pointing at us three up here. The sheriff is an elected official that is everybody's sheriff. It's not our sheriff. We have the fiduciary responsibility to oversee budgets. Elected officials run their own department. So anything above and beyond that, that is your sheriff. And you will have to address it accordingly. And that's all I have to say.
Thank you very much.
Thank you. All right, moving on to unfinished business. We were presented yesterday, and I see Mr. Dobry in here if you want to talk about this anymore, but we had a discussion related to the Amplified Grant Management Software. This basically pertains to us being able to track our grants and everything that goes along with them more appropriately. So, Robert, I'll give you the opportunity now.
I didn't have anything else to add. I just wanted to be available to answer any other questions that you might have.
Gentlemen?
I have nothing further. Go ahead.
I move to approve this order form from Streamlink Software Incorporated, doing business as Amplifund, a Delaware corporation, and Montezuma County. For the Amplifund Grant Seeker Enterprise for managing the annual grant revenue in Montezuma County for 1 year.
Second.
It's been moved and seconded to accept the Amplifund designation between Amplifund and Montezuma County for 1 year in the amount of $34,000. Any further discussion? All those in favor?
Aye.
Aye.
Okay. All right, next up, we also have a discussion for a purchase of road and bridge for a vehicle. It was given to us yesterday, presented by our vehicle maintenance. We do have 4 proposals. The best cost to us is a 2500 Dodge Ram from Mike Shaw in the amount of $55,321, and it will replace a vehicle, an 06 Ford that is over the years of service. Any other questions, gentlemen?
No.
Okay.
I would so move we approve the purchase of the Ram 2500 from Mike Shaw, which was budgeted in the amount $55,321.70.
Second.
It's been moved and seconded to accept the Dodge Ram 2500 from Mike Shaw in the amount of $55,321 for the purchase of the road department replacement. All those in favor?
Aye.
Aye.
Aye. All right. Next, this was not on our workshop yesterday. It was in the previous meeting. And Travis, do you have any more additional information for the holiday vacations?
Yes, so we put it back out to the benefit committee, and the responses that HR got back is they just want to leave it as is, as presented.
Okay.
Motion to approve the employee holiday schedule as presented.
Second.
Okay, it's been moved and seconded to accept the Montezuma County official county holidays for 2024 schedule as presented. All those in favor?
Aye.
Aye. All right. A decision on moving forward for a public safety sales tax. We did discuss this in length yesterday at our workshop. That can also be viewed on our YouTube channel. Our attorney gave us the resolution, but as we were talking about it yesterday, now before we move anything further, that we have to decide on the who.
Yeah.
I think is where we left it, was we said, okay, who actually is this going to be? As a public safety sales tax, that will be discussed in our next workshop on January.
I believe it's January 2nd, but let me check.
Anyway, it'll be our first workshop right after the first of the year.
January 8th.
We'll be discussing the who. Is it just the sheriff's office? Is it the jail? All of those that were presented here, we will actually discuss the who. This is a sales tax. It is not a property tax. Therefore, as what we have in front of us right now, the property owners are the ones that pay for 100% of everything that we do for law enforcement, and we are not taking advantage of any of a sales tax that could be helping us, since a lot of the organizations, or not organizations, but a lot of what happens are those out-of-town issues that we have to take care of for law enforcement. So the who will be discussed at our next workshop. So this resolution does not have a number to it yet because we haven't established the who, and that will be at our next workshop. So no decision will be made today.
And I think what we contemplated yesterday is we're going to workshop this several times. I mean, we talked about looking at first, who is this going to go to, then what is it going to be for, then what kind of rate are we going to need to cover it. I mean, I think Mr. Anderson did a great job of saying, hey, the more specific this is, the better off we're going to be. So this is going to be a series of workshops. This isn't just going to be one thing. This is going to go on for some time.
Right. And I think once we establish the who, then we'll be able to establish the percents that go along with those. So more to follow, more to come. Because with the decline in revenue, as everybody knows, we're faced with increasing costs and declining revenues, and it just doesn't work. It just does not work. So that's kind of where we're headed, more to come. All right, with that, Mr. McLaren, do you have anything to report?
I do. I've been working with Attorney Nate Keever's office on the complaint, on a response to the complaint that was filed by the fractional interest owners of Kinder Morgan's Oil and Gas for the retroactive assessments for the 2008-2009 tax year. This is the issue that went up through the state courts. It actually originated in federal court. It was dismissed in federal court. Then it went up through the state courts, and the state Supreme Court ruled with Montezuma County. And basically the ruling was that these fractional interest owners, so these are like all the different fractional interest owners that own oil and gas, they do not have standing to challenge our retroactive assessments of Kinder Morgan and the fractional interest owners for the 2008 and 2009 tax years. That was an issue. That was a ruling that was issued by the 2008 or by the Supreme Court back. Well, it's been over a year now, and now the case has been refiled in federal court again. And so we have prepared a motion to dismiss. Nate Keever worked extensively on that. I've reviewed it, and that will be filed today. So we're hopeful that we'll again have this matter dismissed in federal court and it won't move forward. Other than that, I don't have anything to report at this time.
Okay, very good. All right, Mr. Anderson, do you have anything?
Just a couple quick things. Working on some partnerships, both with the City of Cortez and Mancos Conservation District. We're still going to have to work out some finite details, but we'll try to get that shored up and get it in front of the commissioners.
You want to do expenditures?
Oh, yes, I do need to do expenditures. Thanks for reminding me, sir.
Might help.
So with the general fund, it's $1,034,923.18. Road and Bridge was $379,280.69. Public Health, $181,083.37. Capital Fund was $30,923.01. Administration Fund, $3,159.32. Landfill Fund, $132,709.88. Check register total was $1,762,079.45. Social services, $1,457,596.82, with a total of $3,219,676.27.
Okay, questions, gentlemen?
No.
I would so move, we accept the expenditures in the amount of $3,219,676.27.
Second.
It's been moved and seconded to accept the expenditures for the month of November for the amount of $3,219,676.27. Any further discussion? All those in favor?
Aye.
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 Anything else, Mr. Anderson?
No, sir.
Okay. Commissioners, you guys have anything?
I don't, I have a Housing Solutions meeting tomorrow afternoon, and City Council really didn't do much of anything, so other than that, wish everybody a Merry Christmas and a Happy New Year.
This past week, I spent Wednesday, Thursday, and Friday at the Colorado River Water Users meeting in Las Vegas. Lots of concerns about what's going to happen with the new guidelines in 26 as far as the operation of Lake Powell and Lake Mead. They're already starting those negotiations between the upper basin states and the lower basin states. I think that Colorado personally has not done a good job in these negotiations in the past. I think we do have a good person representing us now in these negotiations. I've spoken to her on several different occasions, and I think she will do a real good job as far as our negotiations, as long as the other three upper basin states, New Mexico, Utah, and Wyoming, will stay with her. I think she will actually do a good job for us. And we need somebody too, because they basically have run over us in the last negotiations that we've had about how the operation of these reservoirs occurs. Hopefully we're going to do a better job this time. The other thing is they created a new water advisor for the Department of Agriculture in the state, and they appointed Robert Sakata to fill that position. He's actually a farmer up, I don't know exactly where his place is, but it's right outside of Aurora. I mean, it's right on the edge of town, basically. They used to have, it's a pretty big farm, and they used to grow a lot of vegetables. They've cut back now to where they've only got like 14 or 18 employees, but it's a big operation. He's always had a big operation. They were as high as 200 people at times when they were picking vegetables and stuff. So this guy knows about agriculture and water and that sort of thing. So I think that will help, having him as an advisor to the Department of Agriculture for the state also. The final recommendations from our Colorado River Task Force thing over the last several months is finished and will be submitted to the legislature, what our recommendations were. And if anybody wants a copy of those, they can get a hold of me and I can get it to them. But all of that's moving forward also. Also, the Dolores River NCA actually moved through the cabinet hearing with unanimous consent to move it out and move it forward, so it'll go to the floor of the Senate for a vote on it eventually. I don't know when that'll be. I actually heard that it may happen way sooner than we think. But we'll see. We've heard these stories before, but it is moving forward, so. And I think that's all I got.
I hope I can express your optimism on it, but I think that we'll be talking about it at this time next year. And I'm not being pessimistic, I'm just trying to be realistic on this. But it did go through, it did pass last week, prior to them going on winter break. So that was positive, and it did pass unanimously. Couple things that I think we should probably take a look at in our land use code. I think there are just some clarifications and maybe some cleanups that we need to make, specifically, related to the last 3 or 4 hearings that we've had. We can do that, on occasion, just putting it out there. Not that we have to, but I think maybe some more cleanups should be at least looked at. Again, just as I addressed earlier to the gentleman, the sheriff is an elected official. He is everybody's sheriff. We only oversee budgets. And as it relates to budgets, our sheriff cannot continue to give away funding, which he has. And it's crucial. As our revenue sources go down, we have to be cautious of what we are doing. So anyway, our transparency in our budget is out there. It's posted. And if you have any questions, we will have a public hearing on that, as always we do. And everybody will be able to comment in a public hearing. That is always out there and is always transparent. And with that, that's all that I have.
Motion to adjourn.
Second.
It has been moved and seconded to adjourn this December 19th, 2023 County Commissioner meeting. All those in favor?
Aye.
Aye.
Aye.